So we definitely have a theme here of not trusting Silicon Valley, and I'm afraid I will continue this theme. Ari's paper was empirical, and Tomer's discussion was based on discourse analysis. Mine is a more kind of 10,000 meters sort of above a view of what's going on here. Okay, I call it the spectacular collapse of legal categories. And what I would like to do is first discuss the issue of privacy context, which is something which is very popular in the privacy discourse for the last sort of 8-9 years. I will point to the critique of this notion, and then I will move to the legal context and point to their spectacular collapse. All this has sort of crystallized, at least for me, and I will try to convey that following Cambridge Analytica, so we will spend some time on that as well. So our journey begins here. This is an extremely famous cartoon. I'm pretty sure you've seen it more than once. This was the image of the internet in the early 90s. On the internet, everybody can be a dog and nobody knows that you are a dog. It was an image of anonymity, an image of complete privacy. It took only 6 years for this one to show up. This is Scott McNealy, the CEO of Sun Microsystems. The company does not exist any longer, but this is the company that produced Java and many other technologies that we use today. In 1999, Scott McNealy famously stated, "You have zero privacy anyway, get over it." In other words, privacy has died over the short period of 6 years. Of course, Mr. McNealy had a very commercial interest in this statement. He was no, and still is, no sociologist. This is not an observation of a sociologist after, as a conclusion of a research. He has an interest that people will have zero privacy. Similar to this guy, we've already seen this amazing photo, Mark Zuckerberg, also walking by the room when nobody sees him and he controls the room, said that privacy is no longer a social norm. As far as I know, Mr. Zuckerberg is not a sociologist. Once again, he has an interest in people not having privacy as a social norm. So our discussion is in this tension between the dog in the early 90s and do we have privacy or not. Privacy, just to make sure, privacy is live, is alive and kicking more than ever before, despite whatever Mr. Zuckerberg and others might say. By the end of the first decade of this millennium, people have become extremely confused about privacy theories. There have been so many theories, and each of the theories could no longer explain what exactly was going on. And Helen Nissenbaum, she's a philosopher of technology, she tried to sort things out. And Professor Nissenbaum offered the idea of contextual integrity, and this is the book that she published in 2009-10. She offered a heuristic of identifying privacy breaches. How do we know that privacy was breached? And she suggested that first we should identify the context, the social context. So we should identify, for example, the context as health, or as education, or as commercial, or as something else. For each context, we have its norms, and we should look into those norms. For example, in the education system, we should look and sort of figure out what are the norms, and within those, focus on the informational norms. Norms about information, and more specifically about the flow of information. So if we were to look at the educational context, for example, in the university, we would ask, okay, what kind of information do we have about students? So we have all sorts of kinds of information about students. And it flows from the students to the professor to the secretaries, etc. This is the flow of information. And then Professor Nissenbaum suggests that when we look into such a context, and there's a new socio-technological system inserted. For example, at the law school, we shifted a few years ago to digital exams. Students no longer write exams handwritten, they type the exams. we should look at that technology and start asking questions of before and after about the flow of information. And if we see a change, our privacy flag is raised. However, there's some critique of this heuristic and this model. Professor Nissenbaum does not provide a normative assessment to assess the change. Yes, it makes it easier to figure out what exactly has changed, and it's extremely helpful in that sense, but it doesn't say if there are changes for good or for bad in terms of privacy or other values. Sometimes, yes, there's a loss of privacy, but we are willing to trade off our privacy in change of a better sort of value or interest. There's some other issues, and I would like to focus on the critique of the context. What happens when context A mixes with context B? For example, what happens if the university begins selling the information about students? We are not doing that, calm down. What happens if the university begins doing that, selling the information? Is that the educational context, or is that a commercial context? When two different separate contexts converge, under which norms or under which context should we examine what is going on? Then we have a specific context, but then we have this new technology. And there's this saying, famous saying, that a person cannot step in the same river twice, something like that, right? Because it keeps changing. Once we insert a new technology into a specific context, it's no longer the same context, and evaluating it according to the old context no longer makes sense. Big data. The 3 V's, volume, variety, and velocity, we should be familiar with that. I offer the additional 3 M's of mix, match, and mine. But in big data scenarios, what happens is that we take data, decontextualize it, and recontextualize it once again. That's the whole idea. The idea is that we can take data from your health records, from your supermarket shopping habits, from your grades at the university, and from many other sources, mix them together because we can, you guys, the techies in the room can, we can mix all of that together and come up with new insights. There's no longer context here. So Nissenbaum's theory and model are good enough for relatively fixed contexts, but not for newer contexts, especially not those that we are dealing with in cyber space. So, another contextual norm that data protection lawyers, privacy, information and privacy lawyers, and the GDPR, of course, all keep repeating for the last 40-something years is the purpose limitation principle. That means that data collected for purpose A can serve only purpose A. If someone wants to use that data for purpose B, they have to undergo the entire process once again. In other words, ask for permission. This is a legal principle reflecting contextual integrity within the law. So we have some sort of a law that maintains the integrity of a specific context, but then again, contexts might change in various ways. Let's move to legal contexts or legal categories. We lawyers, we tend to differentiate between public law and private law. Within the public law, we discuss the relationship between the state and us citizens. In the private realm, the private law category within data protection, we will discuss the relationship between corporations, Facebook, Google, etc., and ourselves, this time as consumers. And then there's also another third layer of interaction that is between us, human beings. If someone reveals my secret or takes my intimate photo or something like that and publishes it, or etc., there's a privacy tort. It's the relationship between one person and another. These are separate legal categories. Each has their own rules. What we see now is that they are all mixing, conflating, collapsing into each other. So let's go through some of that now. Whoops. Citizen versus state. Well, yes, the state has many perfectly legitimate interests in collecting and processing data. For law enforcement, police, etc., cybersecurity, of course, fighting terror, which has become a global issue, and for the daily management of the state. It's more efficient if we go to one governmental office and then to another, and they already have our information. It's easier for us, it's easier and cheaper for the government. So we have lots of issues that challenge privacy. So some governments around the world have fallen in love with the idea of databases, specifically biometric databases. So for example, in India, the Aadhaar project has now 1.2 billion people in its biometric system. Biometrics are used all over the place, including in Israel now, in our national IDs. We also have smart cities, which include, or so-called smart. Whenever I hear the word smart, I become nervous. It's not so smart in most cases. Smart cities, which collect lots of data. Smart cars, which collect lots of data, autonomous cars. Smart grid of electricity and other utilities, which collect lots of data. There are body scanners in airports. Those of you who just came in, you haven't done that in Israel, but you might have done that in your home country, standing like that in front of either a wall or something that circled you. The previous generation of body scanners showed exactly our body. The current body scanners show a generic image, and if you carry something that you shouldn't, that will sort of beep. That is privacy by design, but only for the second generation of the body scanners. So there are issues here. We would like to enable the state to have its legitimate purposes of law enforcement, etc., but there are some privacy issues there. We have an answer for that. We, the lawyers, we have an answer for that. We have constitutional law and we have administrative law. That sets us a framework and a toolbox to deal with these kinds of trade-offs. And we would typically, and when I say we, I mean we in Israel, in Europe, and in some other countries. In the US it works a bit differently. We would ask, is there a legitimate interest? And if the answer is yes, we can continue. It's a checkbox. We should ask, has the government explored alternative means, less intrusive? Then we would ask about proportionality. Is there a fit between the purpose and the means, etc.? We would typically require judicial oversight, in other words, a court that will see what's going on and issue orders, an objective, neutral kind of body, and due process of law. Now, this does not mean it always works perfectly, but at least we know how to approach a constitutional level issue which regards privacy. Then we have the second layer of corporations versus citizens. So ISPs collect data and they collect metadata such as our location. So Waze has huge quantities of data about its users. Google, Facebook, even the city bikes in different cities in the world which have become popular. The supermarkets, of course, know our purchases over time, and from that they can figure out how healthy we are. Do we eat only kind of, healthy food, organic, or do we buy a lot of fatty kind of food? How many people are in our household? What is our economic status? Do we keep kosher or halal or other sort of religious concerns, etc.? A lot of information that can just be deciphered just from collecting our data over time, and of course biometrics, etc. How do we deal with that? Well, this is data protection law, which is based on FIPS, Fair Information Practices. That emerged, interestingly, in the United States in the public sphere. Okay, in a post-Watergate legislation, the Americans enacted the Privacy Protection Act, which regulates data that is held by the government, with the government. However, the principles set there have sort of shifted into the private realm with the extremely influential OECD guidelines from 1980 and up until the GDPR, which is now upon us. What do we have in FIPS? A series of principles that try to follow the data. There's a life cycle of the data, and FIPS try to follow the data in its various steps. Notice and consent is the first meeting point between data subject and those who collect the data. There are some limitations about which data can and cannot be collected, some limitations about the use of the data, and then we, the data subjects, have some rights to access the data, require that it is amended if it is mistaken, and now also probably in some places at least the so-called right to be forgotten. The data processor has duties of confidentiality and data security, and there are some mechanisms of public and private enforcement. Now, this is not perfect. It's far from perfect. There are lots of issues with FIPS, especially with new technologies, with big data, etc. I asked earlier, has anybody read the privacy updates? Hardly anybody reads that. That means that our notice and consent are a bit fictitious and not very real. However, this is the framework. The GDPR adds to that. So first of all, it's applicable throughout Europe directly. Soft globalization, it has a global impact. It strengthens current rights, such as it enables users, data subjects, to withdraw their consent. It prefers by far opt-in to opt-out, etc. It adds new duties and new rights for us, the data subjects, such as data breach notification, which is also part of the Israeli regulations. It adds the right to be forgotten. It adds data portability. And it also enables or requires what Ari has discussed earlier, privacy by designs, the appointment of data protection officers, etc. So we have looked at the public law category and the private law category. This guy, Mr. Snowden, has told all of us that those two have collapsed into each other. What has happened is that he revealed that the US government, and probably some other governments around the world, have been extensively using data collected by private companies, and not always with judicial oversight. And for those who have actually read the USA Patriot Act, which was enacted in 2001, shortly after 9/11, that was no surprise. The principle is there, it's in the law. What was surprising was the extent of the collection of data and its transfer from the private sphere, from the private companies to the government. Why is that a conflation of the legal categories? Because it bypasses all the constitutional guarantees. It means that if regularly the government had to approach the court and ask for an order, now they no longer need that. They can call, the NSA can call its friends at Google, Facebook, and the other companies, the other data giants, and say, hey, we have this investigation, can you please help us? According to Section 215 of the USA Patriot Act, they can, and they will be immune if they do so. And this bypasses many of the constitutional guarantees. My colleague, Professor Niva Elkin-Koren, and I, we called that in an article we published in 2002, we called this the invisible handshake. Now, we move into privacy 2.0, which is a term coined by Professor Jonathan Zittrain of Harvard. We collect lots of data about ourselves and about our friends. So those of you who have Fitbit of various kinds that counts your steps and takes your heartbeat and all of those, many people share that with their friends in various platforms. Okay, how many steps did you do today? And it might actually be good. It might encourage people to reach their 10,000 steps or whatever benchmark that supposedly we should. People take photos of each other constantly and post them online. Do you ask permission before you take a photo? Do you ask permission before you post a photo online? Do you ask for permission of your friends before you tag the people? Some people do, many do not. There are social norms here which are not yet clear. To some people they are very clear, but to others they are not clear at all. They're still in negotiation, these social norms. Okay? Now, this guy, Christopher Wiley, this is Cambridge Analytica. This is the whistleblower of Cambridge Analytica. He has changed his hair color the other day and posted it on Twitter, so this is not an updated photo of this guy. This is what happened, as far as I understand, in Cambridge Analytica, and the jury is still out because there are lots of questions there that are not yet clear. Each of the users of Facebook, 1.2 billion users globally, have entered into a contract which nobody has read with Facebook. In certain years, that contract said that if we download an application into the Facebook sphere, that application can collect data about us, and we agree, of course, but it can also collect data about our friends, our Facebook friends. And each of the hundreds of millions of users at the time consented to that. So it created a network between the hundreds of millions of users and Facebook, each user allowing Facebook to collect data not only about himself or herself, but about their friends. So that is axis number one of our story. Then Professor Kogan from Cambridge University. He's a researcher, and he approached Facebook, as many researchers do, and said, hey, I would like to do this research. He should have had an ethical approval from his IRB, the Institutional Review Board at Cambridge, and there's some dispute whether he actually had that or not, which is another sort of relationship there. Facebook said, sure, fine, your research looks fine. We allow you access through the API, the interface, to some kinds of data which should have been anonymous. And as you know, Professor Kogan offered users to use a small application in which they can choose whether they're happy or not so happy or miserable or whatever. Very simple, kind of cute sort of expression of your mood at that very moment. 270,000 people said yes to that application and download that. But because of the previous access between Facebook and its users, this enabled Professor Kogan to collect data about 87 million people, resulting in 57 billion connections between people. Now, this is not big data, this is huge, huge data. Professor Kogan then transferred the data, I do not know in which form and how exactly, to Cambridge Analytica, and then Cambridge Analytica, supposedly, so we are told, has used that to, well, manipulate American voters into what they have done or not have done in the elections in 2016. Had users been asked and explained exactly what's going on here, the question or to consent to would not be, do you agree to give us our data in exchange of all these cute applications, The question should have been, do you agree that we collect your data so that we can manipulate you? And I think very few people would have said yes to such an exact description of what exactly was going on. And this is the description, the graphic description of what's going on here. Going back to the law, users have unclear social norms among themselves. Nobody of the Facebook users who agreed to the contract that they have not read, none of those have called their colleagues and friends and said, do you agree that I joined Facebook because it requires me also to allow them to take data about you? Nobody has done that. So we collected data about our friends, and that data was used by Facebook, handed over to other contexts, and into the public sphere, in other words, the elections of 2016. Should we look at this situation as a matter of social norms, as similar, in a similar way that we examine the relationship between people when we, take photos of each other or something like that? Should we look at that under the paradigm of private law and data protection law? It's a relationship between us and Facebook and the corporation, or maybe we should begin thinking of using the constitutional toolbox and administrative law toolbox and saying, well, if there's manipulation of users in the elections, maybe constitutional norms should apply. Maybe we should ask questions about legitimacy and proportionality rather than settle for the data protection level of discussion, that legal category. In other words, what we are witnessing is a spectacular collapse of the different legal categories, one into the other. And we the lawyers this time, we are still trying to figure out what exactly is going on. This is what I was trying to do. And the next step, of course, would be to figure out whether the solution should be within each of the legal categories or some other conflation of legal answers to this situations. So thank you very much. I'm done here. And thank you. We have some 15 minutes so for Q&A. So Ari and Tomer, please join me over here.